Good afternoon, and welcome to the Columbia World Leaders Forum. It's my pleasure to welcome our distinguished guest today, Judge Sang-Hyun Song, President of the International Criminal Court. I want to recognize, first of all, the Institute for the Study of Human Rights, the co-sponsor of this event, and the Institute's faculty members who have worked so hard to give us the opportunity to hear from President Song and have this discussion today. It was a very special opportunity for us. Professor Elazar Barkan is, of course, the director and would be here, but for illness. Yasmin Ergis, adjunct professor of international law and international human rights law at CIPA, and the associate director of the Institute for the Study of Human Rights, and who will fill in to moderate. Matthew Heafy and John Washburn, two of the Institute's research scholars who specialize in studying the ICC. Very important that all of you have helped to bring this about. The International Criminal Court, or the ICC, was founded on the principle that the world's nations are members of a single global community and have a shared interest in establishing international rules protecting our most basic human rights. The ICC commenced its work on July 1st, 2002. Its first conviction in 2012 was of Congolese rebel commander Thomas Lubanga, who was sentenced to 14 years in prison for a campaign of violence against Congolese villages and for the conscription of child soldiers. The ICC's mission, grounded in a claim of universal jurisdiction over particularly egregious crimes, possesses several fundamental challenges. The most significant of these is a familiar one, the inherent tension of enforcing international law in a world of sovereign nations and governments. There is also the ICC's need to more firmly establish its authority by building a record of effective prosecutions and the court's complicated and still evolving relationship with the United States. President Song, who is from South Korea and became the ICC's president in 2009, has assumed a set of responsibilities in a position that are not for the timid or the faint of heart. The difficulties facing the ICC, and also the great promise the court holds for a global society, are made manifest by the current situation in Kenya. The ICC has charged 4 individuals for crimes against humanity committed in connection with national elections held there in December 2007. A chaotic and terribly violent episode in which more than 1,000 Kenyans lost their lives and over 600,000 were displaced from their homes. 2 of the individuals charged last month by the ICC are Uhuru Kenyatta, currently a candidate for the Kenyan presidency, and his running mate, William Ruto. Kenya's Election Commission has cleared Kenyatta and Ruto to remain on the ballot for the March 4th national elections, notwithstanding the ICC's decision to move forward with prosecutions. Kenyatta is one of 2 top presidential contenders, and not insignificantly the son of Kenya's founding father and first president. When I traveled to Nairobi last month to celebrate the opening of the Columbia Global Center there, one could see and feel firsthand the passion and the energy that the Kenyan people are devoting to building a political system that aspires to be a model of democratic participation at every level of government. Their ambition is large, if not yet fully realized. How will Kenyan voters respond to this highly unusual electoral scenario? Will they be moved by a desire to acknowledge an international judicial process beyond their borders, dedicating to dispensing justice for crimes still fresh in the consciousness of Kenyan society? Or will the ICC charges provoke a backlash of national pride and rejection of external authority working to the advantage of those charged? Events in Kenya also expose the conflicted posture of the United States with respect to the ICC. In a recent YouTube video message that he begins and ends in Swahili, President Obama uses his personal connection to the nation to encourage Kenyans to reject violence and intimidation and to hold free and fair elections. The pending ICC charges and the isolation of Kenya that could be an outcome of a presidential election are referenced only implicitly. Nor is there any acknowledgement of the fact that, while the U.S. supports the ICC's mission and principles, the United States has declined to ratify the ICC treaty and therefore is not a member. The ICC's intervention in Kenyan affairs may be particularly dramatic, but the larger issues raised there are by no means unique. To date, 121 countries have agreed to be ICC members. According to the Rome Statute, which created the ICC, the court's jurisdiction exists only after a determination that a criminal suspect's home nation is clearly unwilling or unable to carry out its own fair investigation or prosecution. By design, the ICC is obligated to walk a very fine line, therefore, balancing the interests of justice with respect for national sovereignty. President Song confronts these competing interests on a daily basis, and he has been unwavering in developing the ICC into an institution that can fulfill its mission of critical importance to global society. In 2010, UN Secretary General Ban Ki-moon said of the ICC, quote, "There is no going back. In this age of accountability, those who commit the worst human crimes will be held responsible." I know that our guest today wholeheartedly agrees with that view. Please join me in welcoming Judge Song, President of the International Criminal Court.
Ladies and gentlemen, I would like to thank the Columbia University Institute for the Study of Human Rights and American NGO Coalition for the International Criminal Court for inviting me to speak today, and for the excellent work they do here in the United States and beyond. Actually, since President Bollinger gave you the full explanation about all the basics of the ICC, I have very little to tell you. But it's very good to be back in New York. This is a city that, after Seoul and The Hague, most feels like home to me. Of course, here at Columbia, I may be venturing into enemy territory, since my heart still resides with NYU, where I taught in the 1990s. I am extremely glad to be at Columbia, though. It is a happy coincidence that I am giving this speech in the Italian Academy on Amsterdam Avenue, given that the International Criminal Court owes its founding treaty, the Rome Statute, to Italy and has its home in the Netherlands. I want to talk about the International Criminal Court today, which I am very proud to serve as an appeals judge and president. Though you no doubt will have seen from the title, my topic extends to an issue that is far broader than the ICC itself: the fight against impunity for atrocity crimes. The ICC is very much at the forefront of this fight, not alone, but rather as a central element in a broad global system that brings together international organizations, including the United Nations, states, and civil society, to help address the worst international crimes. I want to start by giving you a historical background to this struggle before going on to discuss the ways in which the ICC is working today to end impunity for international crimes. I will then discuss the architecture of the evolving international criminal justice system, addressing some of its strengths as well as some of the challenges that have emerged. Allow me to begin, however, by going back in time to share some of my own background with you. 63 years ago, an armed conflict broke out in my home country, Korea. I was a 9-year-old boy at that time. For 3 months, during the battle for Seoul City, my family had to hide in a hot and humid underground bunker. It was my task to emerge above ground every day to find food and bring it back to the bunker. To do this, the 9-year-old had to walk 16 kilometers every day. Many times when warplanes appeared in the sky and started dropping bombs on the city, I had to run for cover, dropping all the groceries I had just collected. During daily trips to find food, I passed hundreds of dead bodies lying on the street. To this day, I can precisely remember the horrible stench of the decomposing corpse in those hot summer days. I may have been too young to be mobilized, but I was old enough to realize the immense suffering and destruction that war inflicts. Thankfully, the war ended, and I was able to grow up in relative peace and prosperity, a privilege that I have always been profoundly grateful for. Regrettably, there are still far too many parts of the world today in which peace remains an unattainable luxury. As president of the ICC, I have met with victims in Uganda and the Democratic Republic of the Congo 2 years ago. Some were former child soldiers grappling to rebuild their lives. Other victims were missing arms or legs, or lips or ears, which had been intentionally cut off. The brutality which they suffered reminded me that, unfortunately, with so many countries caught up in conflict, we are far from eradicating the depravity and mass violence. Those of us who are granted the blessing of peace and safety from this horrific violence must always ask ourselves what we can do with this gift. I chose a legal career, and I have believed all my life that it is through law that the worst violence and cruelty inflicted upon humans can be prevented. This is the same belief that has guided the development of international criminal justice through the 20th century. In the aftermath of the Second World War, there was a fundamental overhaul of international structures aimed at preventing the recurrence of the appalling violence of the war. The United Nations and the International Court of Justice were founded to enable peaceful cooperation and settlement of disputes between states. The international military tribunals in Nuremberg and Tokyo were created to try the architects of the shocking atrocities committed by Nazi Germany and its allies. Regrettably, while the seeds of international criminal justice were planted in Nuremberg, the ensuing Cold War rivalry pushed this whole idea into the background. It took decades before new life was breathed into the project of international criminal justice. Two ad hoc tribunals were established in the first half of the 1990s to bring accountability and justice for the heinous crimes committed in the former Yugoslavia and Rwanda. The period also saw a dramatic renewal of the campaign by diplomats, lawyers, and civil society to end the impunity for the atrocity crimes wherever in the world they take place. These aspirations came into fruition in July 1998 when delegates from 160 countries gathered in Rome to negotiate an international treaty that was both the statute for a new permanent international criminal court and also a powerful statement of intent by the international community that impunity for atrocity crimes would no longer be tolerated. In a far shorter time than anyone expected, the necessary 60 ratifications were achieved, and on July the 1st, 2002, the Rome Statute entered into force. The ICC was born as a new independent international organization mandated to investigate and prosecute genocide, crimes against humanity, war crimes, and potentially after 2017, the crime of aggression. Today, more than 10 years in operation, the ICC is seized of situations in 8 countries: Democratic Republic of the Congo, Uganda, Central African Republic, Sudan, Kenya, Libya, the Ivory Coast, and most recently, Mali. All but the latest investigation have already given rise to cases and prosecutions before the ICC. The prosecutor is furthermore conducting preliminary examinations of alleged crimes in Afghanistan, Colombia, Georgia, Guinea, Honduras, Korea, and Nigeria. 2 trials have been completed with judgments issued. The first one was a conviction in a case regarding child soldiers in the Democratic Republic of the Congo. And the second was an acquittal. Both are currently under appeal, as is the first decision regarding reparations for the victims of crimes. It is now clear that the court is at the heart of a global movement that demands an end to impunity for the most atrocious crimes. This movement extends far beyond the seat of the court in the Netherlands. The United Nations is the other major actor in this movement to end impunity. There is a common misconception of the ICC that it is a part of the UN. While the two are close in many respects, the ICC is an entirely independent institution. Delegates in Rome in 1998 recognized that peace and justice were interlinked, and they constructed a relationship between the two institutions that was aimed to be mutually reinforcing, such that both peace and justice could be achieved. The United Nations Security Council, as the preeminent body charged with the maintenance of international peace and security, is the primary forum through which this UN-ICC relationship is played out. The Security Council has the ability to refer situations to the prosecutor of the ICC and has done so twice in the cases of Darfur, Sudan, and Libya. In the situation of Libya, the Council voted unanimously with 15 positive votes, including by the United States, Russian Federation, China, and India. However, just as the Security Council has the power to expand the jurisdiction of the ICC, it can also limit it. The Rome Statute gives the Security Council the power to suspend an ICC case for a renewable 12-month period should the Council believe that it was necessary for the sake of international peace and security. This has never happened in the history of the court so far. While the two referrals of situations by the Security Council have been considered at the time as high points for the ICC, they expose clearly some of the very real challenges inherent in the relationship between the UN and the ICC. By adopting the Rome Statute, states established not just a court, but an entire system of international criminal justice. It's been said accurately that the architecture of the system splits responsibilities, whereby the ICC carries out judicial work, but enforcement is devolved to states. Therefore, the ICC will investigate, prosecute, and try suspects of crimes, but for arrest warrants to be implemented, or evidence to be provided, or witnesses to be protected or relocated, and sentences to be enforced, states must assist the ICC. However, the need for cooperation goes far beyond these technical issues to the political support that the ICC requires. This is evident nowhere more than with the referrals of situation by the Security Council. When it comes to Darfur, none of the Sudanese government officials have so far faced the allegations against them. In the Libya situation, suspects are likewise yet to be transferred to The Hague, and last summer, a delegation of the ICC staff were arrested and detained for a month in Libya while on an official mission. Unfortunately, the Security Council has not provided the ICC the help it needs to discharge the mandates given to it in Council resolutions. For the system established by states to truly function, we need a far more consistent and vigilant approach by the Security Council. There is also a financial question that requires attention. The Rome Statute and the relationship agreement between the ICC and the UN anticipate that the UN shall help fund the costly investigations and prosecutions arising from UN Security Council referrals of the situations to the court. Yet, in both the Sudan and Libya resolutions, a provision was added prohibiting UN funds from helping the ICC. This has meant that the states parties to the Rome Statute have so far picked up the bill for the work done by the ICC stemming from a Security Council decision adopted on behalf of the entire world community in order to preserve peace and security. This conflict will need to be addressed in the near future, and I cannot see it resolved easily without a constructive approach by all countries on the Security Council, of course, including the United States. While the ICC and the UN together may be the most visible leaders of the fight to end impunity, it is ultimately states whose action or inaction will determine the success of this quest. The ICC, unlike its predecessor tribunals for Rwanda and the former Yugoslavia, has been designed as a court of last resort. The legal foundation upon which it rests, the Rome Statute, requires that the ICC only step in if a state is unwilling or unable genuinely to prosecute the crimes in question. This has a number of powerful implications. Firstly, it means that every state joining the Rome Statute can be confident that they retain the primary jurisdiction to conduct proceedings for any crimes covered under the Rome Statute, whether genocide, crimes against humanity, or war crimes. I cannot stress enough that this is both the right and the responsibility of each state. Ultimately, the fight against impunity can only succeed when the national justice system of each state is strong enough to stand against atrocity crimes. This notion has recently attracted a lot of attention in the Assembly of States parties. And there is increasing awareness of the need to involve development agencies in helping the strengthening of national justice systems. I am particularly glad that the United Nations increasingly taking a strong role in this area, since the UN is simply uniquely placed to advance the rule of law in all parts of the world where international assistance is needed. This shows how the real power of the ICC is not in the court alone, but in an entire system of international justice, incorporating international organizations, states, and civil society organizations. With every year that goes by, the normative consensus grows stronger that justice must be done in the case of mass atrocities. By helping the entrenchment of strong legal and societal norms that prohibit massive crimes and human rights abuses, the Rome Statute can help us move toward a safer world in which people around the globe can live and prosper in peace. This is not a task for justice sector alone. It is a goal that can only be achieved with the simultaneous strengthening of democracy, development, and the rule of law. Ladies and gentlemen, since we are at the World Leaders Forum, let me finish by offering some personal reflections on what it means to lead an institution like the International Criminal Court. First of all, as president of an organization with over 90 nationalities represented in a staff of over 700, I have developed an extremely high level of respect for diversity and cultural difference. My time at the ICC has shown me that to lead is to be alone in the eye of a storm. I am surrounded by very gifted and hard-working professionals, and I could not do my job without them. But ultimately, I am the one who carries the responsibility for the decisions that I take. Taking the responsibility means that I also have to be ready to face criticism. Fortunately, I have been blessed with unlimited Asian patience. I have learned to deal calmly with all kinds of obstacles while ensuring that things get done. Leading a judicial institution creates certain very specific challenges. As a court, the ICC is not a hierarchical institution. First of all, every judge is independent and his or her own boss. As president, I am primus inter pares. the first among equals. Furthermore, the ICC's structure includes a prosecutor who is likewise independent. While I coordinate with the prosecutor on issues of a court-wide significance, she is boss of her own office. Then we have a registrar who works under my authority, providing services to the judiciary as well as the prosecutor's office. Solving problems within this complex governance arrangement is not an easy task. Finally, while I represent the International Criminal Court as its president, I'm also a practicing judge in the appeals chamber with cases before me. As such, I continuously have to safeguard my independence and my integrity. And this has an impact on the way I live. For example, the only hobby I have is to play golf, perhaps, on the very rare occasions when I have the time for it. But I always play alone, since I do not want to create the impression that I'm partial to anyone. In the same way, the ICC cannot function unless it retains its independence and its integrity. While we operate in a world in which political considerations often rule, the ICC must stand apart as a non-political judicial institution. This is not easy. But I am convinced that it is the only way in which the ICC can truly fulfill the role it has been assigned in the mission to end impunity for atrocity crimes. Thank you very much.
Sorry, I need to stand. Yes, go ahead.
Hi, I'm Cedra Zaidi, and I'm a human rights MA student here at Columbia. My question for you is, I was recently in Kenya for a few weeks, and everyone that I spoke to, whether or not they supported Kenyatta and Ruto, they either did not support the ICC investigation, or they didn't have much faith in it. So my question to you is, how is the ICC going to continue its investigation and prosecution in Kenya when there seems to be such little local cooperation and support for what you're doing?
The ICC set the opening date, starting date of the Kenya trials. There are 2 Kenya cases. For the one case, it was April the 10th, and for the second case, it's going to be the 11th of April. Since there are so many variables here. We don't know what's going to happen even just tomorrow to the Kenya cases or our prosecutors' activities in Kenya and so on. But we will continue and conduct our judicial work on the Kenya cases as originally scheduled, regardless of the what's going to happen in Kenya politically and otherwise. Their political process should not affect the judicial work of the ICC. At the moment, I must admit that, for example, the logistics aspects of the Kenya case, for example, is not necessarily easy, because these four suspects are under the summons to appear. They were not arrested people. So and they kept on saying they will comply with the ICC procedures and so on and so forth. So how they will come all the way to The Hague to attend the trial, and for how long, and and how the host government will treat them in what way. All these questions are quite not easy. We constantly consult the host governments on these and other issues. But you see, my message is that the domestic political process that's taking place in Kenya should not affect our judicial schedule or judicial work.
Thank you. Yes? Would you please come to the microphone?
Good afternoon. Thank you very much for coming to speak to us today. My name is Marilyn Robb. I'm a senior in Columbia College studying philosophy and American studies. And my question for you has to do with the tension you spoke of about how to have international standards in a world of sovereign nations. And specifically, I'm interested in, you spoke of how it's hard for the ICC to have as much power as it could when nations that are powerful in the UN aren't members of the ICC. And so I'm interested in how you see the future of the relationship between the ICC and countries like the United States that are not currently members.
When I first arrived in The Hague in early 2003, for some initial period, all these 18 judges were not at all sure whether this new creature called the ICC would be able to survive the hostilities shown by the big powers. For example, by the Bush administration and so on. 10 years later, however, I am happy to tell you we have grown to be a fully functioning international judicial institution. And all these statistics and numbers are telling you how much progress the ICC has successfully made so far. These big powers, this is one aspect of the ICC work I should continue to address and work on. These big countries have its own reasons why they are reluctant to to ratify the Rome Statute. For example, it was said that there was an effective checking mechanism against possible abuse of the ICC prosecutors' rather strong power, or the fact that the Rome Statute allows the Security Council to refer the certain country situation to us will inevitably sort of influence this judicial institution politically, unnecessarily politically. Or each country has their own reasons. But I could argue that's not that shouldn't be interpreted that way. I have my own argument. But talking of the United States, the ICC and the Obama administration in particular have been enjoying rather close cooperation on the matters of mutual concern. It ranges from simple intelligence sharing down to the U.S. government's dispatch of 100 military advisors to Uganda with the hope of, helping Uganda arrest Joseph Kony and other LRA, people. And then recent legislation that include the ICC in the legislative scheme that the one who will provide an information which will lead to the arrest of these ICC, the fugitives from the ICC justice will be rewarded with certain cash or other benefit. All these things powerfully indicate that U.S. Government has been quite fully cooperating with the ICC. Having said that, we have to face domestic political reality in this country. In order to get the Rome Statute ratified by the U.S. government, you go out and have to persuade at least 2/3 of the U.S. senators. You see, 67 or 68 U.S. senators. That's not easy, So it will take some time, but since as far as the area of international criminal justice and human rights and democracy and rule of law are concerned, U.S. has been the champion in this area. And it's very clear ICC and the U.S. share these missions, goals, and values. So although it may take many more years, I hope and I believe the U.S. will someday be a member of this ICC family.
Thank you very much for that encouraging answer. Let me see that. I'll try to take somebody from this side. Yes, please, in the back. Could you come to the front?
Oh, sorry. Hello, I'm So Yuntan, a reporter from Columbia Spectator. I have a question that sometimes the actions of international organizations like UN are considered intervention of internal affairs, or expression of national interests, and sometimes enforcing value systems. So how would you balance the international justice and respect for a country's internal policy? And also, do you think what ICC is doing is a representation of sort of universal morals? Thank you.
Well, unlike the ad hoc tribunals like International Tribunal for the former Yugoslavia or Rwanda, as I said in my speech, the complementarity principle prevails in this international criminal justice system where the ICC has taken the center stage. That means it is primarily responsibilities of each state party to conduct necessary, genuine investigation and prosecution of the crimes. I mean, this ICC, Rome Statute crimes in the domestic setting. As I said, only if a state is not able, maybe a whole system is just broken down or whatever reasons, if the state is not able or willing to do so, only then can the ICC step in. So ICC is always there, at least as a safety net, and closely watching what you guys are doing in your own country, regarding the judicial operation. So I think this is a very good solution. It's as I said, I repeat, this primarily the responsibility of each state to do the job, and ICC can only step in if that particular country is not able or willing to do the job properly. So I think this is called the principle of complementarity. So here, in this context, one of the most important thing is how to strengthen the national judicial capacity of each state. You see, a country like the U.S. has a fully functioning judicial and prosecution and police system in place, so no worry about that. But in many countries, don't necessarily have well-functioning judiciary. Then what should we do? You see, although ICC is not a development aid agency or a training academy, but we always try to find some other institutions or that have the experience and expertise and capacity which can help strengthen the judicial capacity, national capacity of other countries. So we've been, on certain cases, the ICC has been a successful matchmaker in this regard. So it is important to strengthen the national capacity in order for this particular principle to function as they should.
Thank you. We have time for 1.5 questions. So, yes, in the back.
Hi, thank you for, can you hear me? Yeah. Hi, thank you for coming here. My name is Chris Kaudzenis. I'm a JD PhD student with the Department of Political Science, and I have the following question. On the legal side, some of the most interesting things that have come from the ICC are some spirited dissents. For example, Judge Bekis has several where he dissents with the appellate chamber findings, but also what certain legal commentators have said as a general tendency of the court to move away from the jurisprudence of prior tribunals as the ICTY. So my question towards you is, can you describe a little bit what goes on in the life of a judge when you deliberate and how it feels to be there in the actual making of the law in the appellate chamber?
Yeah, that's a very interesting question. You see, the Rome statute requires that at least 1/3 of the 18 judges should be women. But the past elections amply showed that more than 1/3 of the judges are women. You see, at the moment, out of 18 judges, 11 are women and 7 are men. So a male judge like me might soon be an endangered species. So this gender composition may have some bearing on the development of our jurisprudence. That's one point. And in the judiciary, in the bench, there is no American judge because you are not a state party. Therefore, our jurisprudence hasn't been influenced by American legal thinking or American practice or American procedure. One example would be witness proofing. After much debate among the judges, we don't want to we cannot accept that kind of American practice, for instance. So this, in this particular sense, the development of our judicial precedent may already be different from that of the ad hoc tribunals. There are many reasons to make all this difference because the ad hoc tribunals do have a primacy, jurisdictional primacy over the national jurisdictions in those affected areas. But with us, as I said, you see, we don't have a jurisdictional primacy. As I said, it's primarily it's the responsibilities of each state to investigate and prosecute all these ICC crimes. So even for that reason alone, the development of the jurisprudence might have to diverge. When we sit around and debate and deliberate on the case, of course, the legal officers and others, just write the research paper citing the cases of the European Human Rights Court or ad hoc tribunals precedents and so on. Sometimes we just borrow or rely on their logics and theories, but I would generally say that we have stronger desire to develop our own jurisprudence. Do you agree, David? Here's my former legal officer who has been working for me for the last 8 years. You agree, more or less?
More or less, but we benefit from extremely experienced judges like Judge Sang, who practiced in a number of jurisdictions, including NYU and Seattle and the like, who do bring American perspectives as well as other perspectives, differences.
I'm actually afraid that we're going to have to end it here. I want to thank you, Judge Song, so much.